Yes. Well, thanks everyone for coming. Thank you, David Wolfson, for saying that he'd only take 10 minutes and then took 15. The barristers do that quite a lot. I am struck by the number of suits and other forms of business dress I can see today. It's a matter of great pleasure to see so many forms of formal dress at one time. There isn't a single set of sweatpants at all, so well done everyone for that. Today we're going to talk about collective proceedings. Everybody here knows about the development of group litigation since CPR Part 19 was instituted, the group litigation order procedure some 21 years ago. Most of you will also be aware of the bespoke scheme for collective competition claims, a scope that was widened by the Supreme Court just over a year ago in, perhaps a little bit more than that, in Merrick and MasterCard. Fewer may know much about the use of the representative procedure to bring collective claims. It's about to be the subject of an important judgment by the Supreme Court in the case of Lloyd and Google. I believe that's due out on Wednesday. But this is a time of fast development for collective claims. It's a good time to take stock, to consider some interesting features and tactical issues raised by in practice, and to assess prospects for the future. Let me introduce the panel. My name is Tony Degar-Robinson. I'm a QC at 1 Essex Court. I have considerable experience of group litigation, and I'm now seeing some representative claims as well. Also on the panel is Neil Back. He's a disputes partner at Herbert Smith Freehills, part of their class action practice. He has a particular expertise in transnational talks, which we will be talking about. We also have Mark Deem. He's a disputes partner in the innovation department at Mishcon de Rea. He has significant expertise in data protection claims, which is of particular interest at the moment. We have Mark Kenker. He's a disputes partner at Keller Lenker. Considerable expertise in collective claims, largely from a claimant perspective. And last but not least, we have Stephen Wisking. He's global head of Herbert Smith Freehills competition, regulation and trade practice sector. Huge experience in complex competition disputes, including, of course, before the Competition Appeal Tribunal. Now, one thing I'd like to start with is the distinction between opt-in and opt-out claims and the growth in opt-out claims in recent years. We all know about group litigation orders. Essentially, that's a procedure for managing claims which have common or related issues of fact or law. It's an opt-in process. The parties seeking to bring the claim can only do so for named claimants who were who've authorized the claim to be brought on their behalf. From the claimant's perspective, the disadvantages of the opt-in procedure are obvious. The opt-out procedure is often preferable, where claims are made by all persons falling in within a defined class, unless they positively elect to opt out. There's no need for the class to authorize the claim, or even for the members of the class all to be identified. Now, unlike the position in the US, we don't have a general system of opt-out class actions, but we do have a relatively new animal, which is the collective competition claim that now can be brought under the Competition Act before the Competition Appeal Tribunal. Stephen Wisking will be discussing that in a moment. We also have representative actions under CPR 19.6. These are opt-in claims. There is, of course, a constraint that all parties to the claim must have the same interest in the claim, and that can often cause difficulties with damages claims. Mark Dean will be discussing that. It's easy to say that our procedure is defective and inferior to the better developed US procedure, but don't be too hasty. General rules making it easy to bring opt-out claims can make the life of businesses very difficult, and that is a balance that has to be taken into account. Anyway, rather than taking up further time with my comments, let me hand over to Stephen, who can tell us all about competition.
Thank you very much. So, a couple of slides. What I wanted to talk about today, in the time available, was just give a little bit of background to and the features of the statutory competition collective actions regime, and then to talk about where we are now and the sort of issues that are emerging in that regime. Just by way of background, so what we're dealing with essentially are, in terms of competition claims, are damages claims brought by the victims of infringements of competition law, so either anti-competitive agreements or abuse of dominance. And those claims are either brought following a decision of the European Commission or the CMA, so there's an infringement finding, or they can be brought on what we call a standalone basis, where the claimants actually have to prove the infringement of competition law. There's been quite a long gestation process leading up to the competition collective action regime. So I think it's always been thought competition claims are well suited to a collective action because you've potentially got damage which is widely distributed, particularly at a consumer level, but in circumstances where the claims are complicated and expensive to bring. So, generally claims weren't being brought by consumers. So what you saw in the past were essentially business-to-business claims, either brought by individual businesses or sometimes grouped together to bring damages cases, but not from consumers. There was a statutory consumer opt-in competition claim mechanism, but it was used once in the replica football kit case where something like 300 claimants signed up, and it was considered not to be a great success. I mean, they were claiming for 20, 30 pounds each. So there was lots of government reports, a lot of back and forth, both at the EU and the UK level. And it got to a point where the idea was that you could have a sector-by-sector approach for class actions. And in the 2010 finance bill, the government got close to introducing a class action for financial services claims, but that got lost as part of the 2010 election. And so what we're left with is the statutory competition regime, which came in 2015. And even that has had a slow start because of the way the limitations provisions were set up. It meant that it was difficult to bring class actions in respect of really historic conduct. And then because of Merrick's, which I'll come to, which Supreme Court decision, which has held up a lot of cases pending that decision. So in terms of the features of the regime, essentially it allows you to combine individual claims brought through a representative. It's only available in the Competition Appeal Tribunal, and what's key to it is there is a certification process. So the tribunal has to allow the proceedings to start by way of making what's called a collective proceedings order. The claims can be opt-out, which Tony's talked about. It's limited in the sense that insofar as you're dealing with non-domiciled claimants, non-UK domiciled claimants, they have to opt in, but otherwise it can be opt-out. But equally, it can be an opt-in claim as well, an opt-in mechanism, and it's ultimately up to the tribunal to decide which form it should take. What's interesting is that in the appropriate case, the tribunal can award aggregate damages. So it doesn't need to make an individual assessment of loss at the level of the individual class members. And what that also means is where damages are not distributed, because there's a long history, certainly in other countries, where you have these sort of awards of damages that claimants don't always come forward to collect. The undistributed damages can go to a designated charity, which at the moment is the Access to Justice Foundation, or can be applied on account of the representative's costs. What they can't do is go back to the defendant. In terms of the requirements for getting a collective proceedings order, first of all, you have to have a suitable representative. And in practice, the people who've been coming forward to do that have been people with an interest in the sector, which is the subject of the claim, usually have very strong CVs, and they are presenting with very sophisticated plans for the conduct of the litigation, funding, all that kind of thing, and they tend not to be challenged. What we are seeing, though, is the emergence of carriage disputes. So this is where someone launches a claim, and then someone else comes along and wants to launch the same claim on behalf of the class, and the tribunal is going to have to determine, and we've got a couple of cases, has to determine who's going to get carriage of the dispute. And as you can imagine, there's quite a lot at stake in those sort of cases. Self-evidently, there's got to be an identifiable class, so it's got to be objectively clear who are members of the class. And then there have to be common issues. And the test here is same, similar, or related issues of fact or law. So as Mark may come to in terms of CPR 19.6, that's a very strict test. This is more relaxed. And in a recent case, the tribunal has said, look, fundamentally, it's got to be the same question. It doesn't need to be the same answer for all class members that determines whether we have a common issue. And it essentially has to be something that advances the litigation. It doesn't need to it doesn't need to cover the entirety of the litigation. It could just be a key issue in the litigation, and then once that's resolved, you could end up with separate claims being dealt with. The other big area which has been a subject of debate is it has to be suitable. The case has to be suitable for a CPO. And there's a whole range of factors for the tribunal to consider. These include things like, is it broadly appropriate for the claim to be brought as a class action? A cost-benefit analysis, what's the size and the nature of the class, whether it's suitable for an aggregate award of damages, because that's quite a powerful factor in favour of grant of a CPO, those sort of factors. And as I mentioned, whether it should be opt-in or opt-out. So when the regime came in, there weren't very many cases. A few started. One of the early cases was a case called Merrick's, which relates to interchange fees. That case was denied a CPO. It went on appeal to Court of Appeal, which overturned the CAT's decision. That then went to the Supreme Court, and that judgment came down at the end of last year. And I think that's considered to set a relatively low bar for certification. So essentially, the Supreme Court said, look, when we're thinking about this, we should be looking at comparing class actions to individual claims. Is this better than an individual claim? And in consumer contexts, chances are it will be, because consumers are rarely going to bring these sort of claims on their own. That the damages assessment doesn't need to be perfect, so you don't need to come with a fully formed economic case about how you're going to assess damages, and that was one of the issues in Merrick's. And there's a long piece in the Supreme Court judgment about the broad acts and how important that all is in terms of assessing damages. That there isn't a higher merits test than ordinary litigation. So essentially, claimants don't need to meet a higher standard than the strikeout or summary judgment test. And when you have aggregate damages, you don't need, as I said before, you don't need to be able to show what the loss is at each individual level for the purposes of distribution. So distribution of those damages needs to be fair, but it doesn't need to align on a compensatory basis to individual loss. So these are all obstacles that have been raised by the defendants against the grant of a CPO, and the Supreme Court basically rejected all of those. This slide just shows where we are at the moment in terms of cases, and I'll maybe come back to the detail of them later in the discussion. The blue boxes are cases which are follow-on cases. So these are where there are regulatory decisions that the claims are based on. And this is what everyone thought would happen, that you would get these cases following on from regulatory decisions, bringing claims for compensation for consumers. The pink boxes, though, are the standalone cases. And those are where the consumer groups are trying to prove infringement as well. And they're all based on abuse of dominance. So, for example, the railway cases are essentially cases where the claim is that dominant rail companies have failed to make cheaper boundary fares widely available to consumers. So consumers have ended up paying more than they should have done. So there's a degree of innovation in terms of the sort of claims that are being brought. If you can see it, the foreign exchange and trucks cases have carriage disputes, which I mentioned before. There's also, in some of these cases, the argument is being made by the defendants that they should be opt-in claims rather than opt-out, and that because of the size of the class or the ease with which claims could be brought, consumers should be required to opt in rather than get the benefit of an opt-out. In one of the cases, Le Pacharel, which was it's a claim against BT, the tribunal deals with the cost-benefit analysis, and in that case, although they granted certification, they looked at the claim size, which was 30 to 50 million. They looked at the costs, which was said to be about 11 million. Sorry, this is the sort of trains case, not the BT case. The individual claims were worth about 30 to 50 pounds per consumer, and the tribunal said in the round, it's probably not a case where the cost-benefit analysis stacked up, but because certification is being done on a sort of multifactorial basis, they nevertheless certified it. But it's an interesting example of where the tribunal is going to start looking at the overall structure of these cases and say, well, look, is it worth doing them? And this concern that, you know, at the end of the day, the only people that benefit from them are lawyers. And then down at the bottom left, which you may not be able to see, but there's a case which is apparently been issued but doesn't appear on the CAP website, which is a home insurance case which is based on the CMA's compare the market decision. What's interesting about that is it's a decision by the CMA of infringement of competition law where it's currently being appealed. So the decision may get overturned, but nevertheless, someone has quite early on brought an application for certification, which may well be a sign of the times that we will see these cases coming very quickly, in part possibly to avoid a carriage dispute, because if you get in quickly, someone may not try and compete to bring the claim. But I think it's probably a sign for the future, but I'll stop there.
Thanks very much. Let's move on. We've discussed competition claims where they may be opt-in or maybe opt-out. The other form of claim, this one is before the court, where they are definitely opt-in, is representative claims. And a good vehicle for discussing that is the possibility of representative claims for data protection on data protection grounds. And speaking to that will be Mark Deem.
Thank you very much, Tony. Good morning. In the world of collective claims and data, where competition has trailblazed and led the way, data is very much playing a second and catch-up role. I think it's probably important in the very limited time available just to give a quick overview of where we are in relation to data claims at the moment and how we deal with collective claims in this space. But I think we have to have some historical context here. If we go back to 2014, at that time, the Consumer Rights Bill was going through Parliament, and at that time, it was anticipated that for all consumers, there would be a standardised opt-out procedure for which their claims could be brought. Now, as it went through Parliament, the then Business Secretary, Vince Cable, and Stella Creasy for Labour made some very powerful interventions saying that they were fearful of US class action litigation starting up in this country. They talked about the prodigious and constant litigation that you see in the US in the class action space, which only benefit the funders and the lawyers. And so ultimately the decision was taken just to proceed on a statutory footing of these claims in the competition space. And Stephen has spoken a little bit about that, and certain safeguards were put in place. That's the first bit of context. It's been revisited on a number of occasions, most recently by the DCMS early in February this year, but the decision is still very much we're going to keep this in the competition space and not put collective claims in the data space on a statutory footing. The second bit of context that I think we just need to bear in mind is the impact of GDPR, that four-letter acronym that either strikes fear at the heart of corporate UK or sends everybody's eyelids to start to close as you mention it. But the GDPR was important for a number of reasons. Firstly, we ended up with a world in which notifications are now mandated for data breaches in this country. And that really shone a light for the data subjects as to how their data was being treated and perhaps how it was being misused by others. The second thing GDPR did was it accepted that it is possible for claims to be brought by data subjects who have suffered either a material or a non-material loss. That is, a non-pecuniary loss is now possible in the world of data and data claims. And the third thing GDPR did was it asserted that it would be possible for representative actions to be brought, but not in the same way as we anticipate by 19.6, but by a representative body on behalf of the data subjects, and not-for-profit being the sort of paradigm example. So GDPR has sort of normalized and brought focus to the world of data claims. Now, the third aspect I just want to quickly touch on is what is the anatomy, as I call it, of a data claim? As Stephen said, competition is a perfect case for lots of individuals at a very diverse base of consumers who have been affected and have suffered a loss. And the same is true in the data space. Unfortunately for data claims, it is very unlikely that a claim would ever be brought by a business on a business, because we're dealing with personal data and the infringement of that personal data. So it tends to be individual data subjects that are being the ones who are wanting to bring those claims. And when we are talking about a very low level of potential damages, maybe £200, £300, £400, you can instantly see why it would not be cost effective for that to be brought individually. And even on an opt-in group litigation order basis, it could be very difficult to get those claims up and running, because quite frankly, human nature is such that if we are faced with the prospect of signing up to join a claim which might pay out £200 in 2 years' time, we may be reluctant. And so that brings us to the representative action, where the idea would be that actually you're part of an ill-defined class, or not identified within that class, but you might just get a payout in due course. And so those three pieces of the jigsaw, I think, are all relevant to where we find ourselves now with the need to proceed on the basis of 19.6 or the representative actions. As I've said, data follows competition, and one of the competition cases that had always been a stumbling block in relation to 19.6 was the case involving British Airways and Emerald Supplies. And the big problem that was identified in that case, and which led to British Airways successfully arguing for a strikeout, was the inability to be able to prove that all members of the class would have suffered the same issue or the same loss, effectively. And that brings us to the way in which we try to get around that in the 19.6 space in data, and Lloyd and Google. Now, what Lloyd and Google did is it decided that we're going to try to find the lowest common denominator to establish that same loss. So long as you could say that the entire class suffered a minimum level of loss, would that be sufficient to establish the same issue, the same loss for purposes of 19.6? High Court didn't like it, and it was thrown out. Court of Appeal thought that it would be possible, that you could proceed on this non-pecuniary loss for loss of data, loss of control of your data, and that provided the entire class would have that same minimum lowest common denominator, that would be sufficient. And that brings us to where we are today, 2 days, 48 hours from the Supreme Court, who are now going to be opining whether or not they indeed agree with that position. Competition leads the way, data follows. We saw in Merrick's in the Supreme Court there was a certain loosening of the position, and the court was trying to find a way to enable these consumers to be afforded some sort of rights. What I'm going to say now is obviously not future-proofed. I don't quite know where we're going to go on Wednesday. If we go down the line that finds purely for Google, it will be for, I think, fear that this might open up the floodgates. We're aware of a lot of cases that are sitting at the traffic lights at the moment. I think there are 8 or 9 at the moment involving some of the big tech companies. Anecdotally, there are more that are waiting to break cover, if I can say that. If it finds wholly for Mr. Lloyd, it will be because actually the court finds there is a very real need to support these individual data subjects in trying to get some redress for their loss. I think realistically, it's probably going to be a hybrid somewhere in between those two points. But that, in a very short amount of time, is where we are in relation to data claims and collective actions at this moment.
Thanks very much, Mark. Let's have a slight change of direction now, and also perhaps a change of pace where time is pressing. I'm now going to hand the floor over to Neil and Mark Kenker, who are going to talk about a piece of substantive law, really, which has been influenced by the possibility of collective claims, and that's to do with transnational torts and the development of liability for torts committed often out of the jurisdiction where the parent company may be here and may be the one worth suing. Let me hand over to Neil, first of all.
Thank you, Tony. What are transnational torts? I'll start with. That is a term that can cover a multitude of sins, or well, I suppose alleged sins. Certainly, as these cases have manifested themselves before the English courts in recent times, they have comprised, as Tony said, a claim against an English domiciled parent company and its subsidiary, overseas subsidiary, in respect to alleged wrongdoing in the country of operations of that overseas subsidiary. And the theory of liability that has been advanced is that the parent company owes a duty of care or its foreign law equivalent to those affected by the acts or omissions of the overseas subsidiary. Those claims are brought to the UK by suing the parent company as of right, and then the overseas subsidiary, that on one view would be the proximal wrongdoer in any claim, is brought in as a necessary and proper party under Practice Direction 6B to that parent company claim. The central question for many of us looking at these is, well, in what circumstances would a parent company owe a duty of care to third parties affected by the acts or omissions of its subsidiary? To those of us brought up as company lawyers with Salomon as an article of faith, that's quite an alarming prospect. The key decisions to date are those two on the slide, Lungoy and Vedanta, and Okpabi and Shell, both Supreme Court decisions, respectively concerned with alleged environmental pollution in Zambia and Nigeria. Both proceed under Zambian and Nigerian law, but for the purposes of the duty of care analysis, it was assumed in both cases, and that was the same as English law. It's important to note at the outset that both are jurisdictional challenges, and so the focus of the court was on the arguability of the parent company duty of care. What needed to be shown was that, as put, it would survive a defendant's summary judgment test, i.e. it couldn't be set against it, it had no real prospect of success. And so what they are not are definitive statements of the principles. Vedanta went first, Shell was parked while Vedanta was decided to thrash out the principles. Most importantly for present purposes, the Supreme Court made absolutely clear that the idea of A owing a duty to C in respect of the acts of B is not a novel proposition in English law, as was suggested in that case by the defendant. Indeed, we'll all remember from law school Dorset Yacht and the Home Office, where you had some Borstal boys that escaped supervision and caused some damage to yachts in Poole Harbour. And so it was said, by analogy, your subsidiary could be your errant Borstal boy, and your parent company could be the defaulting supervisor, depending on the facts of the case. And so all will depend in any given context on the nature of the parent-subsidiary relationship and how any corporate group actually organises and runs itself. Then in Okpabi and Shell, the claimant sort of took the ball from Vedanta and ran with it, and the claimants in that case advanced 4 bases on which they said that a parent company duty could arise in this context. First of all, it was said that if a parent company engages in the management or joint management of activities of the subsidiary, so a duty of care could arise. Equally, if it gives defective advice or procures the implementation of defective policies in the subsidiary, so a duty of care could again arise. Equally, if it's actively promulgating policies and getting the subsidiary to implement them, so it's intervening in potentially in a relevant way in the way that the subsidiary runs itself. And equally, if the parent is holding out a degree of supervision and control to the wider world over its subsidiary, that could equally give rise to a duty of care. But as I say, these are very much jurisdictional cases, and we've yet to get a reasoned judgment on the principles. And I think Mark is going to give us a claimant view of these cases.
Yeah, so whistle-stop tour in terms of claimant's perspective, these are really important, it's a really important gateway for claimants to get redress where there's no ability in there or lack of a system within their local jurisdiction, be it Zambia, be it Nigeria, or else. We heard from Lord Wilson at the outset about how England and Wales should be and is the pinnacle. In circumstances where organisations operate in different jurisdictions without fear of redress because of a lack of an established system, funding lawyers to run these group claims, it's important to have this gateway. It's also, I would say, given the quality of lawyers in the UK, for us to be leading in this respect and not hiding behind jurisdictional challenges which
last for a number of years and actually don't, from a claimant's perspective, move things forward. I think it would be, from a claimant's perspective, if there was more of an approach to addressing the problem rather than setting back, that might assist. And actually it might assist in terms of moving funders away from supporting actions where the duty of care, I would say, is being stretched beyond what is reasonable. I suppose a note to caution to myself as a claimant lawyer, ultimately on these cases you're going to face a very adept, well-resourced defendant who is going to challenge jurisdiction, who is also going to be stress testing the duty of care and also stress testing, is the claimant group, has the claimant group suffered the loss which you're claiming as a collective, because often the origination of these groups isn't as thorough as it might be, and therefore grabbing 200,000 people and pointing it at a petroleum company will not, in some cases, certainly face the initial stress tests of the lawyers on the other side, but also once the court gets involved, can be an expensive experience. Back to you.
Yes, I'll just cover a couple of points, I think, where I think these sort of tortious principles are taking us next. As I think many of you all know, the movement in sort of hard and soft law attendant on ESG and business and human rights issues doesn't afford a wealth of private law causes of action, and I think it might fairly be said that these tortious principles are sort of filling a gap at the moment as things stand to bring those private causes of action. 2 points. Firstly, supply chain claims. It seems in principle that if a parent can owe a duty to a third party affected by the acts of the subsidiary, so it might fairly be arguable that it could be said that a end purchaser of products could be liable for the acts or omissions of someone in its supply chain, and that proposition is currently being tested in the courts in a claim brought against a couple of the tobacco companies in connection with alleged labour abuses in Malawi, where there is no contractual nexus as between the tobacco companies and those said to be the proximal wrongdoers in that case. Secondly, disposal of assets. There is a case currently before the courts, Begum Moran, which was concerned with the disposal of an oil tanker in circumstances where it was said to have been known to the seller that it would be sold to a breaker's yard with poor health and safety practices. And it was said by the Court of Appeal that gave rise to an arguable duty on the basis that foreseeable harm would be caused by third parties by selling it in such circumstances. Or it could be said that selling it in such circumstances created a danger such as to give rise to a duty on the seller to seek to manage or mitigate that danger to prevent harm to third parties. And so for those of us on a day-to-day basis involved in asset disposals, that's going to make us all think quite carefully about whether there's a long-tail litigation risk once you've got your asset off the books, as it were.
Thanks very much, Neil. I see that our time management actually it turns out not to be quite as good as David Wolfson's. So we were going to be spending some time talking about the tactical issues that one has to wrestle with the various different kinds of collective claims that can be made, the tactical issues relating to GLOs, representative claims, and of course sort of informal multi-party litigation, which can sometimes be adopted as in phone hacking in order to achieve a similar effect. I don't think, have time for that, but one point that I would invite Stephen to speak to is a particular issue arising in relation to competition claims, because it does seem to me that it's very interesting.
So in these competition cases, certification is happening, but the next frontier is settlement. And the reason why that's an issue is that, as I mentioned, because of the way aggregate damages work, defendants won't be able to get undistributed damages back. However, there is a very strong incentive to settle because it's possible to provide in a settlement agreement that you do get undistributed damages back. The problem is for opt-out cases, the tribunal has a role in approving the settlement, and that process is yet to be determined how it will work. And what the rules and the guidance sort of talk about is that the settling parties will have to go to the tribunal, and they'll have to go with evidence as to why the settlement is good, possibly supported by expert evidence, things like what the cost of litigation will be, prospects of success, all of this kind of stuff in a very public way, because it needs to be open to the class members to see this process and potentially challenge it, and if they don't like the outcome, to opt out from the settlement. And you can see that from a defendant perspective, this is not super attractive to be doing this in a public context, particularly as there may well be situations where there is parallel litigation going on elsewhere in the world, or even in this jurisdiction. So it's difficult, and it's yet to be worked out how it's going to work in practice. But one suspects that settlements are not going to come quickly because of that.
Thank you very much, Stephen. We now have just under 10 minutes left, and what we're going to devote the last nearly 9 minutes is to development, where we're going in the future. This is a fast developing field, and it's interesting to speculate as to where we will end up in a few years' time. So on that question, I'd like to ask Stephen, first of all, about what he sees, what he assesses as prospects for the future in relation to competition claims.
So I think there's three things. One is, as I touched on, we'll see follow-on cases coming very quickly from regulatory decisions, and will become part of the landscape, much as you see in other places like the US. Second thing is potentially innovation around standalone cases, so people trying to potentially shoehorn what might be seen as consumer-type cases into a competition framework to benefit from this statutory regime, which is, it's quite active at the moment. And then the third thing, which others may want to comment on, is there's quite a lot of, although it's a statutory regime, there's quite a lot of law coming out of the competition area, and to some extent that may be a model for other areas in terms of thinking about the suitability of the representative, how you deal with carriage disputes. Those are potentially going to emerge in the 19.6 cases as well. So you could see competition sort of influencing the development of opt-out cases in those other areas.
Thanks very much. All good to know that there's a new area of law that we all need to keep on top of in order to do our jobs properly. Neil, now, I believe that you've got things to say about so-called ESG claims.
Yes, in an ESG context, I've already mentioned, the way tortious principles are being stretched to create private law causes of action. Secondly, I mentioned climate change litigation. It's yet really to come to these shores. There have obviously been cases in the Netherlands, and equally in Australia and New Zealand, there have been certain cases brought, public law cases, and also cases brought, again, on a tortious basis. Those, particularly the tortious cases, have yet to gain any real traction, particularly because the duty is potentially infinitely expandable, so the Australian courts have said so far. And equally, the case on causation can be quite difficult. But it nonetheless seems to me inevitable that those kind of cases will start to be being advanced here, if only a sort of campaigning litigation more than anything else. Equally, greenwashing type claims, people overselling the green credentials of products, one can imagine those coming to these shores, particularly in an investment context. Every copy of the FT seems to have adverts for different financial instruments that claim ESG credentials of one sort or another. And it seems inevitable when the economic tide goes out, some of those claims will be found wanting, notwithstanding the efforts of regulators to try and police it. And equally in a consumer context, consumers are, of course, becoming much more astute about the green credentials or otherwise of the products they buy. And reading across from, for example, the US food labelling litigation, it's entirely conceivable, particularly if the consumer regime becomes much more of an opt-out regime, claims being brought by consumer groups on the basis they were essentially missold consumer products on the basis of false or exaggerated ESG claims.
Thanks very much. We now have about 5 minutes left, so we're back on target. And having said that, I'd like to ask Mark now to talk about his sense of where we're going with data protection claims.
Great. No, thank you very much, Tony. I think as you sort of heard and I touched on earlier, data claims are always going to be very much a tough claim to bring on an individual basis. So we really need to be looking at ways in which they can be brought on a collective basis. GLOs and opt-in cases are always going to be difficult. Even if cases are underway, we've seen in the instance of, for example, British Airways and Ticketmaster, that sometimes actually the defendants can really use the process of a GLO to their advantage in trying to force an early settlement, which may not necessarily be the best way through this for the claimants. So representative actions represent probably the best way forward for collective claims, and so all eyes are very much looking at the Supreme Court this coming Wednesday. If it goes in favour of Mr. Lloyd, then I think we will see a lot more claims in this space. If we do see those claims, unfortunately, we're really very much at the foothills of all of this. We have to work out how these are going to play out in practice. Stephen's mentioned settlement as being a very big area in the competition space. I think settlement is going to be equally important to read across into the data space, and just how these claims will play out going forward, and the pressures that will be placed to try to come to a settlement. If we don't, however, get a judgment that enables representative actions in the data space, I think this isn't really going to be the case of the door being shut. These are claims that are worthwhile, or these are individuals that will have potential claims that they can be brought. And the one thing that is very clear from the GDPR is that the GDPR wanted to empower those data subjects who had suffered some data breach with an effective judicial remedy. And if we have 19.6 shut in our faces by the Supreme Court as a data claimant side of the profession, then I think we're going to have to start looking at other ways in which we can actually make sure that these data subjects do have that effective remedy. A few other points just to note. As I said, I think it all is very much up in a state of flux as to how these things will play out. We haven't really touched on test cases. Test cases is another area of collective actions or collective actions or collective claims, which could be of importance in relation to the data space, perhaps. And the second thing is, I think we're actually going to start to see a convergence between Stephen's world and my world. I think data as a sort of a monopolistic asset is going to be one where we might actually start looking at ways in which these companies that build up huge banks of big data and hold it close to their chest, hold it for themselves. It may well be that we have to start looking through the competition world to see if that gives us a way of getting the redress that the claimants seek.
Thank you very much, Mark. I'm really pleased with my team, who've come in with 2 minutes and 30 seconds to spare. I wonder whether anyone has any questions. I know that there's an electronic means of articulating these questions, but since I don't have anything electronic in front of me, I'm perfectly happy to take questions the old-fashioned way. Does anyone have any questions? Well, I'm going to take that as a mark of success. And thank the panel for their time today. There is a lot of change coming, I think, regardless of the outcome in the Google case, and it's as well to be aware of it. And I hope the audience is more aware of it than they might otherwise have been. Thank you very much.